Welcome everyone, and thank you for joining us for today's webinar, How to Ethically Use Technology in Your Practice, presented by Jim Calloway. My name is Stephanie Palin. I'm a marketing manager at MyCase, and I'll be your host today. First, I'd like to give you a few tips about participating on GoToWebinar. The webinar control panel is on the right-hand side of your screen. This is where you can control audio, chat with me, and submit questions. Please use the questions pane to submit your questions all throughout the webinar. I'll be collecting those questions and saving them to ask Jim at the end of his presentation, but please don't wait until the very end to shoot those over to me, or I might not get to your question. Also note that these slides and the recording will be available by end of day tomorrow on the MyCase blog, and it will be emailed to all registrants. When you close your webinar today, a 5-question survey will pop up. All you have to do is answer those 5 questions and you'll be entered to win a $100 Apple gift card. The survey will only take about 30 seconds to complete, so it's worth it. If you'd like to join the conversation on Twitter, the hashtag to use is #LawyersUsingTech. This webinar has been approved by the Wyoming State Bar and also the Florida Bar for 1 hour of general CLE credit that can count towards 1 hour of ethics CLE credit and 1 technology CLE credit. If you are a Florida Bar member, note course 2505R to self-report your CLE. Please note we do not provide certificates for this webinar. Today's webinar is hosted by MyCase, so before we jump into things, I'd like to give a quick overview. MyCase is a web-based law practice management software that takes care of your daily practice requirements for calendaring, contact management, document management and templates, time and billing, client communications, custom workflows, and more in one solution at an affordable price. MyCase is priced for solo and small firms at just $39 a month per attorney and staff. We also offer MyCase websites for our customers. The one-time fee to set up and build your custom website is $9.95. Then there's a $50 per month fee to maintain and update your website. Our websites teams make some beautiful websites that, and they can build one for you and your law firm too. We use a modern professional design built specifically for your firm. The websites contain social media and blog integration, and best of all, a client portal, which is completely integrated with your MyCase software. So now you and your customers can log into MyCase directly from your own website. Next up is payments. Are you accepting payments from clients online yet? You really should be, and it is easier than ever. MyCase now has a built-in credit card payments feature for our payment service. MyCase customers can accept online payments from clients using both credit cards and checking accounts, which are also known as e-check or ACH payments, seamlessly through their MyCase account with no third-party integration required. Last but not least, we enjoy hosting educational events for professionals in the legal industry, and that's why we're all here today. So let me tell you a little bit about our presenter. Jim Calloway is the director of the Oklahoma Bar Association's Management Assistance Program. He is a former chair of ABA Tech Show, a columnist for Law Practice Magazine, co-producer of the monthly podcast The Digital Edge, Lawyers and Technology, and has blogged at Jim Calloway's Law Practice Tips for the past 12 years. When Jim is not talking legal tech, you can find him tending to his 2 French bulldogs, Crunch and Josie, which he describes as the most expensive little dogs in the world to maintain. I saw a picture of them and they're pretty adorable, so I'm sure it's worth it. Jim, thank you for being here today and sharing your legal tech knowledge. I'm going to pass the mic off to you now.
Well, thank you very much, Stephanie. I appreciate this opportunity to be here. I'm going to cover a lot of material very quickly, but you will be given all the slides afterwards, as was noted, so you can look up anything you may have missed. But at the beginning of 2015, the Wall Street Journal changed the name of its marketplace section to Business and Tech, and they stated when doing that, as you see here, that every tech business was now a technology business, whether it's taxi cabs or taco delivery. Let me suggest to you that if taxi cabs and taco delivery are technology business, businesses, how much more is a law firm that does almost nothing but process and deal with information and information technology business? I wrote about this in the ABA's Law Practice magazine, and you've got the link there. You'll be able to get the link from the materials later. But every law firm today is a technology business, and frankly, you have no choice whether you like it, embrace it, resist it. You law firms run today on technology, and that will be true even more so in the future. We lawyers are so busy that oftentimes we seem to avoid today's technology tools. I've got the little cartoon here of the guys using the square wheels because they're too busy to try out the round wheels, and sometimes that's what I feel like is the challenge for lawyers, is that nobody ever files a grievance against you or fires you or doesn't pay you because you didn't update your office technology, and so it sometimes is not the highest, most urgent priority. For you in Florida, a little shout out that Florida is the first state to have mandatory technology CLE. We'll see if that grows or not, but I'm going to tell you, here in Oklahoma, we've been doing lots of legal technology CLE for a long time. This summer, I'll be finishing my 20th year with the Oklahoma Bar Association as their practice management advisor. One thing we all understand is that the legal service marketplace is undergoing many changes. Some of these changes are related to the new things that can be done with technology. Some of these changes are disrupting previous vendors and sometimes doing away with them. You don't see many people who are serving as travel agents these days, and if they do, it's because they have a very specialized practice. And so we're going to talk about these changes. One of these changes is the change to the model rules of professional conduct that has incorporated technology competence, if you will. Now, it's in a footnote. Bob Ambrosia here, as you see, has called it the duty of technology competence, but it is in a comment, I will say, an official comment. But essentially, what now the majority of the states would have adopted some version of this rule say is that lawyers have to consider both the risks and benefits of relevant technology. So we are going to talk a little bit about these things, using these red lights and green lights to talk about whether it's a risk or a benefit. Sometimes it's both. But before we start, let's do a poll question. The poll question for our attendees is, has your state amended the rules of professional conduct to add this comment on the risks and benefits of relevant technology? Answer number 1, yes. Number 2, no. Number 3, I should know that, but I don't. And number 4, which I hope doesn't get a huge response, I could care less. So let's pause for a few seconds, Stephanie, while we let people respond to our first poll.
Yes, thanks, Jim. And that poll should be on all of your screens now. If you can please make your selection. And it looks like majority has voted. So I will go ahead and close these polls now. And I'll share the results. Okay, so has your state amended the rules of professional conduct to add to the comment on the risks and benefits of relevant technology? 29% said yes, 11% said no, and then the majority, so 60%, said I should know, but I don't know that. And you did get a 0% for I could care less, so your wish came true, Jim.
Thank you very much for that. And you can go to Bob Ambrosia's Law Sites blog to see that, or you can call your state bar and check on your rule changes if you're not aware. Another rule change that happened back in 2012 was a rule that talked about protecting confidential information from inadvertent or unauthorized disclosure. Before the advent of some of this technology, disclosing confidences was more of an intentional rather than an accidental act in most cases. And then we came up with fax machines, and all of a sudden sending the fax to the wrong person became the kind of poster child for inadvertent or unauthorized disclosure of client information. But the bottom line now is we have obligations to protect this client information, and that is enshrined in the rules in about 50% of the states as well. So let's first talk about security. When I want to talk about security, I know a lot of lawyers think the reason they went to law school is avoid topics like this. In fact, Justice Willett the well-known tweeting justice of the Texas Supreme Court, when asked why he chose the law as a legal career and went to law school, tweeted back, "I was told there would be no math." And I know sometimes many of us feel like that, but let's just review a few things that I think most of you know quickly. What is the cloud? Here's a good picture of what the cloud actually is. These are giant server farms in often football-sized field covered areas, and they spend a fortune on air conditioning bills, because if you look at all those racks, every one of those is a drive that are all working together in unison, and these places generate a ton of heat. So now when we talk about the cloud, that concept of the cloud being this kind of fluffy, white, intangible thing, that's just because when they design network outlines of where we put the printers and where we put the fax machines and whatever, the IT outline showed the cloud as a symbol for the internet. But the cloud is really server farms, and in fact, most cloud services now are on one of 2 or 3 major service farms. Most of them are either with Amazon or Google. But we still love this quote back from 2010 from a person that says, a writer that says, "Cloud computing is a fancy way of saying the stuff's not on your computer. It's on a company server, maybe many servers. Obviously, you want to be careful as to where those servers are located. You wouldn't want them to be located in a country that didn't protect data privacy and data integrity." And then another thing, this is a little Oklahoma flavor, again back in 2010, from our then ethics counsel, who wrote that it does seem to have more of a risk, but rock-hard certainty is not required. You're not guaranteeing that your system is absolutely invulnerable. And I think an analogy would be there would have been no time when we would have thought that a lawyer who was burglarized was at fault, and yet with the computers and the cloud, it feels a little different. Let me give you my personal opinion on the cloud. I'm a big believer in the cloud for many reasons, but you need to stay up to date. You need to actually read these terms of service that are given to you, and you want to know what you don't know and periodically review your vendor security measures. And there's sometimes that special circumstances warrant special precautions. We've seen the situations where people have had, they call them revenge porn cases, where personal photos that weren't meant for the public have been distributed, a lot of times from celebrities. And you know, there might be a situation when you have something that is so damaging that you want to keep it in a special place, even though you feel like your cloud service provider is okay. But you can always make a different decision for that. My personal thoughts: your security risk is any connection to the internet. So particularly for you solo and small firm lawyers, if you're connected to the internet, it's already at risk. You have this feeling like, well, as long as I have it here in my office, it's under my control, but if I put it out there on the cloud, who knows what. But a business grade cloud vendor that you pay for has security experts and engineers on staff, and if you're in court all day trying a case, how can you be your own IT director when a new bad thing is released on the internet and everybody needs to update something? It's even hard for you to do that when you have some IT outside source person. So using a properly vetted vendor, in my view, to secure confidential information can be viewed as outsourcing your data security to those more qualified and responsive. And I will note, and I'm not just saying this because MyCase is our sponsor, but I'll note that when you have these companies that were built from the ground up, from the initial concept, to protect lawyers' client information, you know that they pay a lot more attention to that than some of the free consumer services that we see out there. If you don't know the ethics opinions from your jurisdiction, or if your jurisdiction doesn't have an ethics opinion, this map resource from the ABA Law Practice Division has links to all of the various states that have cloud ethics opinions. Nobody said that you shouldn't use the cloud, but all these opinions were written by committees of lawyers, so many of them have a little bit change of the wording. I notice on the map Wisconsin isn't blue there, but they've actually authored opinion that is at the link. So take a look at these ethics opinions. review them, and I think you will find that you should be comfortable with the cloud. Practice management software in the cloud, you'll notice I've changed my light to green here. There are so many benefits to using the practice management software tools that you really have to factor that into your conclusion, because if your client needs a document at 3 in the morning and they call you at home and you're using cloud-based practice management software, that's really easy to do. It's impossible using paper files without somebody physically driving to the office and firing up the fax machine or scanning and attaching it to email. And that's just one of the many benefits. I really believe that lawyers who have not switched to digital client files, and I mean paperless files, are going to be in significant trouble over the next 4 or 5 years. You just can't function as a business where you are doing something in 15 minutes that another lawyer can do in 2 clicks and 10 seconds. Right now, many law firms still have the drop everything and hunt for the lost document or the lost file, and that's something that we'd like to avoid. So let's just talk real briefly about practice management software tools, and I can assure you I would be saying the same thing to all of you whether there was a particular practice management tool serving as the sponsor of this or not. Here's from Minnesota Lawyers Mutual. You've got the link there if you want to look at that. But the access to files and documents remotely with a cloud-based software system, a practice management software system, you can access everything from home in the same way you would access from the office. So if you're a small firm lawyer or a parent and you have to stay home with a kid one day when that child is asleep and you've got a few minutes you can work, you can log into the office and do everything that you could do from your normal workstation. You can save on postage, paper, document storage costs. You can save protection of client files in the event of a disaster, flood, or fire. And the main thing is you have 7/24 access to every document and every open file from any location. Most of these practice management software solutions either have a mobile-friendly website that you can access on your phone, or they've built an app for you to access via your phone. So that's really great. I will back up a second. I may have lost some of you when I said paperless. At this point, I'm not saying that I think you have to shred all of the paper in your office. Some of you will have a hard time making this change, and until you're really facile with an iPad or other device to display documents in court, it may make sense for some law firms to go ahead and keep a paper file as a backup file, or to keep a paper file so you can take it to court and more easily deal with it. The challenge with that is we lawyers tend to operate by precedent, and human beings tend to operate by doing things the way they've done them in the past. And so if you keep those paper files around, you have a chance that people will quit using the practice management software and will go to the paper file. Another thing I love about them is the ability to keep notes when you talk with clients and notes when you do something, particularly when there's multiple lawyers in the firm. How nice to log into your practice management software when a client calls you asking you some questions, and when you pull up the area to make the notes about the questions you're receiving and your answers, you see where they've talked to one of your partners the day before. So maybe a client's trying to get a second opinion. So in my world, those files would have never been that easily obtainable. Those notes from that call would have probably still been a day later on a legal pad somewhere and need to get pulled out and bratted in. But how about protection of client files in the event of a flood or other disaster? What if this was your office location? In Baton Rouge, they had a terrible rain that caused a terrible flood, and lawyers went from having their offices with, it'd been raining for a couple of days, the yards were too wet to walk on, you had to walk on the sidewalk, to the office being under 6 feet of water in less than an hour. Can you imagine what that would be like? Well, I don't have to imagine, because a day or so after that flood, I got a call from the Louisiana Bar Association asking if I would come and talk to their lawyers. I had done this before after Katrina, when several of us went down and talked about how you rebuild. But this time was a little bit interesting. I sat through the Ethics Council of the Bar giving a lengthy presentation that included a good long talk on how to dry out paper. That shutters down all of your spines if you're a paper-only office. But one thing I noticed was some of the lawyers that I knew from Baton Rouge weren't at the seminar. And I realized, guess what? The people who were at the seminar were the ones who had been devastated by the flood. Everybody had been devastated by the flood that was in the flood zone, of course, but the lawyers who were using practice management software, as soon as they found a computer and an internet-enabled location, they were back up and running because their files were all stored safely in the cloud. So they weren't at my seminar. They were probably out signing up new clients, where the lawyers at my seminar were having to do a much more extensive bit of recovery. Let's move on from those kind of heavy topics, talk a little bit about something fun like social media. Social media is fun, but posting online can be dangerous about clients. Posting about your clients can be very dangerous. You see my red light here. I've got dozens of these stories, but just a couple of vintage ones, if you will. This Illinois assistant public defender who posted about her difficult clients and clueless judges. First of all, she was at a rather smaller courthouse, and secondly, she talked about the clients and gave them fake names in a way it was easy to identify them. So maybe she'd refer to them by their first name only or change their first name slightly. She was doing lots of inappropriate information, and she ended up getting fired and getting disciplined by the bar, both. And why you would think this is okay, I'm sorry, is completely beyond me. Here's another one from a Florida lawyer. Some of you in Florida may have heard of this one, where the public defender thought it was noteworthy that the client's family, when the murder trial had started, had brought underwear and clean clothes for the client to wear in court, and there were leopard skin underwear, leopard colored underwear. And so she held up these briefs and took a picture of them and posted on social media, "This is what my client's family thinks is appropriate to wear in court." Obviously, she didn't think she had that many friends on social media. It wouldn't be that big a deal, but somebody saw it. They reported to the judge, and the judge had to declare a mistrial on a homicide case. That would not endear you to the judge. So social media is fine, but posting about clients is very dangerous. Don't trust any privacy or security settings, because if you're posting to social media, you're sharing with someone, and that someone can then share your post with other individuals who can share it with other individuals and other individuals. Facebook changes their privacy settings so frequently. It was a challenge for a while. They've kind of settled down now. But still, if it shouldn't be disclosed, it shouldn't be on social media. If you do want to share, get the client's permission in writing. There may be a great thing that happened in the case that's very unusual that you want to blog about or post about, and your client may be thrilled for you to do that because they won the case and they're happy. But people change their minds later. People get excited about things. They may get angry with you on another situation. So if you want to post about a client's matter, just get the client to give you permission in writing, and then you have got a good defense that you breach confidentiality. Still, you have to have good judgment. And again, like that one public defender, disclosing the client's name or something like that is just not going to work, because most of these dockets are online. Still, lawyers can't afford to be ignorant about social media. I have all these lawyers that talk about, I don't want to do social media, I don't like social media, I don't want to know anything about it. Business clients need lots of social media policies and advice. This is a great business opportunity for all of you. In fact, I think there will be many lawyers, perhaps some of you who are attending this seminar today, that will branch out as some technology consulting, because we're to the point now where technology risks are legal risks. Family law cases, if you do family law, you know, it's like every contested hearing, especially about child custody, now has a lot of social media evidence, and soon social media evidence will be a part of many types of trials. I am reminded of the Casey Anthony murder case where they were examining somebody about their Twitter account, and it was very clear that neither the defense lawyer or the prosecutor had taken the 20 minutes on this nationally televised trial to learn how Twitter worked. And so those who watched the video later or those who watched it live could see that they were confusing friends or followers on Twitter with people that Twitter had suggested that you might want to follow you. And it was not a big part of the trial, so a lot of people don't remember it, but professionally it's embarrassing to be entering evidence when you don't understand how the evidence works. Let's talk about email. Love it or hate it, most of us use email every day, and it's a challenge to use email correctly. And so you see here I have the green light and the red light. We use it all the time. It's simple to use. That doesn't mean you can't make mistakes. So, poll question number 2. Do you use email encryption in your law practice? Answer number 1, yes. Number 2, no. Number 3, I don't have the tools, which is a little different. And number 4, I have the tools, but I don't do this. So 4 different responses, some of which overlap a little bit, but give us your best answer because I'm really interested in this one from practicing lawyers.
Yes, I'm interested in this one too. Curious to see the results. So the poll is out there, everyone. Please go ahead and make your selection. And I will be closing the poll shortly. Okay, looks like majority has voted. I'll close the polls. And we'll share the results. So do you use email encryption in your law practice? 32% said yes, 38% say no, 27% don't have the tools, and 3% have the tools but don't do this. Is that about what you expected to see, Jim, or is that a higher number?
I was hoping encryption was a little stronger, but I'm not at all surprised about don't have the tools. And coming up, we're going to tell you how you can have that tool today in your office as a result of the seminar for free. Not that free is the best one, but we'll move on there. Okay, surely after the last year, I'll just leave it at that, you understand that unencrypted email is not secure. Security experts say that email is a lot more like a postcard than a letter inside an envelope, and anybody can read all the notes in transit. And the email goes, again, from various servers. There's backups through all the email system. It is at this point, I work for the bar, so I don't like to say quotable things, but you shouldn't be emailing Social Security numbers, medical information numbers, account numbers, credit card numbers. You shouldn't be emailing those type of things unencrypted. It's not protecting the information because it's really easy to hack into emails. These emails, again, just go across the internet. It's plain text. If you have an attachment, it's plain text. Anybody that happens onto this email, now they'd have to have a little bit of expertise, but they can find it and use it. Another thing I'd say is no more using free Gmail for business communications. If you're using Gmail as your main email, and you haven't done this, please go and look at this link I've given you. They've changed the Google Office or Google Business. They change this name all the time to G Suite. But for $5 or $10 a month, you can have more security features, lots of other different things, $5 or $10 per user per month. If you ever had Gmail compromised, like a certain presidential advisor did, you would sure want to be able to say to any disciplinary authorities or in your deposition that you didn't just use the free service, but you paid extra to have more security. In addition, the security will allow you to manage accounts if you're using something like Google Calendar for your office calendar. So when somebody leaves, you have the ability to shut off their access instantly with your administrative tools. So you also can use the Gmail for Business will let you put your law firm domain name in there as your email address, which is a great advertising for you. I think everybody should be using their law firm domain name as their email address, even if it's Gmail or something hiding behind it. I do have some homework for you. I'm going to give you lots of links and lots of other options. Now, this pains me as an Oklahoman to have to brag on Texas. It's just not in my DNA. But this Opinion 648 of the Texas Center for Legal Ethics on when may I communicate confidential information by email doesn't necessarily come to a conclusion as much as it does a great job of outlining all the times where anybody would go, oh no, you couldn't use unencrypted email for that. And so I would encourage you, I've made a cute little bit.ly for you here, TX Opinion 648. I would encourage you after the seminar's over to read that ethics opinion because I think it has some valuable lessons in it. And frankly, again, even though it's from Texas, I view it really as kind of the state of the art on my thinking, particularly for solo and small firm lawyers. Okay, this is for those of you who answered the seminar, I need to encrypt, but I don't know how. Here's a quick and dirty way to do one-off encryption. This would not work as a total business process. You need something a little better because this is going to be complicated. But if you need to send a divorce decree that has 10 bank account numbers and stock brokerage account numbers today out by email, here is a way to do that. You can either password protect a Word document, and you see here I've given a little show you a little link on how you can do it, or you can password protect a PDF file. This actually encrypts. I'm not going to say it's the highest level of military grade encryption, but it's definitely encrypted and it's definitely safe. And then you call the recipient and give them the password over the telephone. So if you have to do something in the next week or two while you are waiting on coming up with a more permanent encryption tool, this is really a great thing for you to do on a case-by-case basis. You might want to write down those passwords, but again, you'll always keep a copy of the document or whatever it is before you encrypt the one for the client, so you'll always have that clean copy and don't have to worry if you forget the password. You just send another one to the client. Here's another interesting read on encryption that came out a few weeks ago. It talks about how to encrypt your entire life in less than an hour. Has a bunch of really good tips. Many of these tips I'm going to be talking about today, but I will note one exception. They talk about using the Tor browser for encryptions, but the Tor browser is also your pathway into the dark web where a lot of bad things go on, and I wouldn't want anybody using the Tor browser who was not conversant with it, and really I put experts there. There's other labels, but now there's a lot of good uses for the Tor browsers. I've noticed some of the major newspapers now have anonymous tip places set up on the dark web where people can post tips and whatever without their identity being disclosed and whatever. I'm not saying it's all bad, but this is a great article on encryption that talks about how encryption is increasingly important today. And by the way, if you have your laptop, if you have a lot of personally identifiable information on your laptop and you lose it, the states vary on whether you have a duty to notify your clients you've lost the data. Notifying them you've lost all your clients you've lost data would be pretty scary. But HIPAA, with healthcare information, provides that lost information that was encrypted does not require notification because it's lost, but it's not accessible to the person that finds it. And so I think that's an analogy that we lawyers can feel comfortable with, that if we lose encrypted data, we probably don't have to suggest that. So here's a tool that I've visited with these people at this company before. I like this tool. It's called Citrix ShareFile. You can send large attachments as a link in the email, and there's this handy Outlook plug-in tool. I'm going to pop this up here so you can see it. So right in your Outlook bar, you can attach encrypted files or you can request files. And that request files feature is really, in my view, huge. I saw a lawyer that had that in his signature block. If you need to send me confidential files, click here. I might not do that, but they've got this data room. You can access files securely, sharefile.com. It is a monthly charge. They're working on a legal edition. You can't find it from the website. If you're a solo practitioner, I'd ask you to call them because the base level that only costs $16 a month doesn't include the Outlook plugin. And I really like the Outlook plugin with the Citrix tool. The client portals within practice management software are one of the really great ways to do this. Many of you have already dealt with the client portal before, as I said, with a healthcare provider or something where you get your lab results by logging in and seeing your lab results there. This idea of using a product like MyCase or some of its competitors that allow you to easily set up this client portal, and then your client can log in and see all of the documents while the matter's going on. You can also send secure messages. If you want to send a text or an email, then your text or email can just basically be, hey, I've uploaded something in the portal. Go take a look at it. And I don't know how well you can see it. It depends on how big your monitor is, but this is actually, we set up a dummy account here for Bruce and Betty Wayne's divorce, and this is actually Betty Wayne's document portal that we have set up for her. So you see Darla Jackson, who works in our office, has posted the petition for dissolution there. A nice way to do it, and the thing I like about it is you don't have to scan again or do another process. It's all built within your practice management software. Having practice management software, I could go on and on about the benefits of practice management software, but having practice management software, this is one really great thing. It solves your emailing problem by sending confidential documents. And, you know, it might even be handy for a client who is on the road to be able to open up their file and look at all their different documents if a lot was going on. So I'm a big fan of practice management software and of the client portals. So, poll question number 3. Do you use a client portal currently to share information with clients in your law practice? 1, yes. 2, no. 3, I don't have the tools. 4, I have the tools but don't do this. And I know that Stephanie is probably more interested than I am even on this particular question.
Yes, I am very interested in this. And so to clarify too, do you use the client portal so through practice management software or any other anything outside of email is what you're saying here?
Right. Any portal where they log in as opposed to an encrypted email.
Yep, perfect. Okay, great. So everyone, please go ahead and make your selections. And I will go ahead and, okay, majority is voted. We'll close the polls and share our results. Okay, so our results are in. Do you use the client portal to share information with your clients? 14% said no, said yes, so that's pretty low. 55% said no. 26% don't have the tools, and 4% have the tools but don't do this.
Well, I'm not doing a sales pitch for MyCase or any of its competitors, but I can assure you, whether it's MyCase, your practice management software, or whether it's something like Citrix ShareFile, it's important now, unless you're not sharing any client information other than face-to-face. If you're sharing any of it electronically, this is very important. So I am thrilled that all of you attended this seminar and have this on your radar screen. And again, if you think this is unusual, most clients, when you tell them about a client portal, at least the ones who are old enough to have frequent contact with the healthcare providers will say, oh, I've already got patient portals for my healthcare providers. Okay, let's talk about passwords. Big red light here on passwords. Here's a little thing for some of you. If you see your password on this list, you really need to know that when hackers come calling, this is the list they start first before they use any sophisticated tools. And I am at least gratified to know that password, after many years as number 1 on the list for a password, has now dropped down where it's just about 10th on the list. But if you think you're being clever by using password as your password, you must have a different password for all the different sites you log into. They must be at least 9 or 12 characters, maybe longer. They must include numbers and other things. You can't just string together a couple of words from the dictionary anymore, because a brute force dictionary attack will put combinations of words together. And it's really impossible to remember the number of passwords you need to remember today. So this is really the most simple thing to tell you. You've just got to use a password manager. Here are 3 common ones. There's others. LastPass has even gone to having a free service, although the one service is $1 a month, and that lets you use it both on mobile devices and on your computer. And so these will build an encrypted file that has your passwords all in it. Now, you may decide, if you've got one financial account with millions of dollars in it, you may decide that I'm just going to remember that one, even if it has tens of thousands of dollars in it, and not put it in your password manager. But we really don't have any. LastPass had a breach that was a potential breach, but no passwords were compromised. And really, most of these, because they have a decentralized method of keeping the passwords vault on your computer. So you just need to know 2 passwords now. 1, to open your device, and 2, to open your password manager, which will then store all your passwords safely. What about password recovery? That's an interesting situation. This is a somewhat irreverent take here, but when Sarah Palin was running for vice president, her Yahoo account was hacked. The way it was hacked by somebody knowing her, because her emails were everywhere, so you could easily find her address, and somebody just went in and tried to recover the password, and one of the questions was, where'd you meet your first love? And she, of course, told in her biography she met her husband at high school, and sure enough, that was how the hacker got into her email. So it's great to have all these cues, but if you've had anybody in your family pass away, I mean, they don't even have to have a Ancestry.com account. You can go look at notices for funerals and whatever, and you can find people's mother's maiden name. So if you're going to use these recovery tools, which I strongly suggest you have to, although with a password manager you'll probably never use them, but think about coming up with a bogus phrase that you always use for your mother's maiden name or first pet, so there's no way anybody could ever hack into your account by using your password recovery service. Security is increasingly a problem, and it's again more and more an ethical duty for lawyers, and so this is a challenge. Many of us aren't doing this yet, but we've all got to start using, at least on our primary important accounts. If you've got some newspaper account that doesn't have your credit card on file, maybe not. But we've got to authorize two-factor authentication, which is essentially something you know and something you have, or perhaps something you are. So the password is what you know, but there's other ways to do. The common way to do this is to have the passcode. When you enter your password, it texts a code to your phone. You open up your phone, you enter in those digits, and you're good to go. Even if somebody broke in that information provider and stole every username and every password, they still couldn't get into you because they don't have your phone, so they can't log into your account. So that's a very great tool, but I will warn you, when you set this up, take great care to save the instructions on what to do if you've lost your phone, because that could be a problem to find yourself suddenly locked out of everything. That's another reason I say pay the extra $1 for LastPass, if you're $1 a month for LastPass if you're using them, because they have tech support if you pay for it. We've seen these keychain dongles, where I saw the big firms have a keychain that changes the number every 5 minutes, and they've got a computer changing it every 5 minutes too, so when you get ready to log in, you type your username and password in, it prompts you for the code, you look at your keychain, you write in the code. I am not a big fan of using fingerprints or retina scans for online services. It's certainly fine to use a fingerprint to unlock your phone, but you've only got 10 fingerprints, and once those are compromised, they're gone. You can't reset your fingerprints. And so at this point, I want to be a little conservative and say, let's use the text to my phone method rather than using my fingerprint and losing that forever. Free Wi-Fi is too expensive. Many of you now know how to tether your phone to use Wi-Fi. I carry around one of these MiFi cards. It's pretty expensive. I pay Sprint, I think, $60 a month for mine, but I can set up a cloud that 5 different people can use. And we've actually had ABA committee meetings where I provided the internet access because I had my MiFi card. But any Wi-Fi you use, you should never use any Wi-Fi that doesn't require a password, first of all. But even if you go into some place like Starbucks and they give you the password, the guy in line behind you is a hacker. He gets the same password. He sets up a honeypot or a hotspot on his own computer, calls it Starbucks Fast Access, and then everybody who logs in through him at the Starbucks is now exposing all of the information on their computer. So we're all going to use Wi-Fi from time to time, and up in a hotel room it's probably not that great a risk, but if you're really going to be using it heavily, if you've got really a client data that might be hackable or of interest to hackers, I really want you to look at these MiFi cards or learn how to tether with your phone or figure out what your other alternative is. I'm changing my look for just a second here because I want to make the point that digital security is very important for law firms. And the main thing to understand about digital security is it's not about you, your IT department. They have their duty, but it's about people clicking on email attachments. We had one the other day where hundreds of bar members were sent out an email saying a complaint had been filed against them by a client. Click here from the OBA. Our members were mostly smart enough not to fall for that. But you've got to do regular staff training at least twice a year. You've got to have brief training for all new hires. And if you've got a big firm, you may want to go to one of these vendors that lets you fish all your own employees, and those who fall for it get an extra level of training. Ransomware, we're seeing a lot of ransomware these days. Even like big hospitals are being locked down with ransomware. And don't forget, if you get ransomware and it locks up every computer in your office and says you have to pay a ransom, if you haven't planned well in advance, you're probably stuck paying the ransom and funding these criminals. But to recover quickly, you don't just need your online backup, because often your online backup is just data. You're not backing up the Windows operating system or all your applications. So to recover quickly, you need a mirror image of the computer. So you first put in there, format the computer, then you put the mirror image. Instead of having to track down your disk for Word and all those keys and whatever, you just put it in there. And then you load your data into that system. So there's kind of a two-step process recovering from ransomware. What do we do in the event of any data breach, including ransomware? You need an incident response plan. It needs to be in writing. It needs to be physically printed out somewhere, because if there's an emergency, you may not have power, and include all the steps and who needs to be contacted, phone numbers, and whatever, because when there's a disaster, it's often not just a disaster. We've had tornadoes recently in New Orleans, and so you got a lot to deal with. So write down this incident response plan now so people can grab it and go by it when there's an emergency. And for you lawyers that represent businesses, this is a great thing for you to get into, teaching your clients how to do incident response plans or doing incident response plans for them. I've written another little article here that encapsulates some of the things we've talked about today. It's on the OBA website. It's free to all. Anybody who wants to go, it's mainly there free for lawyers. But I would encourage you to take a look at this article as well. And it's a good link to share around the office, even for those who didn't attend this seminar. Talk about the benefits again a little bit, and we're running short on time as we intended. Actually, we're perfectly on time, but there's going to be more automation in your future. We hear a lot about artificial intelligence, and people say, "Oh, the machine can't do what I do. I make these judgments," and a lot of their judgments are just if-then or data-filled questions, but that's okay. But you're going to be automating your office more in the future. Here's an article I've written on office automation that talks about kind of basic things to do automating your office. That's coming, and one thing that we know is the billable hour is going to stand in the way of that a little bit, but that's coming, and you need to understand that once you develop that first template, that reusing the template is a great way to increase your benefit. Like I said, you have to look at maybe charging a flat fee or something, but that's okay. Automated document assembly should be one of your automation priorities. We generally produce documents, whether they're now printed on paper or sent out as PDFs or sometimes in other formats. We produce documents, and there are many affordable solutions. There's a company called Pythagoras and a company called The Form Tool at theformtool.com. They have very affordable solutions that are plugins to Word. Now, there's work here. If it was easy, everybody would be doing it, and we're already seeing some state bars. I know the Iowa bar has got a bunch of automated documents they put online for their members. We're seeing the gold standard is Hot Docs, but for medium-sized to smaller firms, Hot Docs is just a little too complex and expensive and requires too much training. Now, Hot Docs is the gold standard. Let me emphasize that again and again. And Hot Docs is great, but it's going to require about a week's worth of training. If you're going to build your whole firm around it, you need to have redundant training. Licenses are fairly expensive. I think $800 for a developer's license, $300 for each user. So it gets to be a little bit expensive, but lots of different ways to automate your documents. And again, you can do some research. There's all sorts of quick ways to automate documents with templates and other things that can save you some time. Here's another article I've written. I guess I don't have the link for this one, but if you Google my name and Document Czar, you will find it instantly, I promise you. But everybody in the law firm does not have to be an expert at Microsoft Word or how to design templates and all this. You need to have a point person or two in the law firm who's your document czar. And then you see with my check marks over there, they can develop the templates for others to use. They can standardize document creation and storage. They can be the one in charge of this automated document assembly project. Then they can talk to management about what this means. If this thing we used to take and spend 4 hours doing now takes only 45 minutes, do we really just want to bill hourly for that, or do we need to make some adjustments? So this was written back in July, August 2015. One of my favorite articles I've ever written. Hopefully that'll be enough to direct you in that way. Finally, you can't really talk about the future of law practice without talking about Richard Susskind. He wrote a book several years ago called The End of Lawyers. But this future of the profession is not, written with his son Daniel, who's another professional, is not just about lawyers. It's literally about how technology will transform the work of human experts. We've all heard about assembly lines and manufacturing plants being automated and costing a lot of people their jobs. We didn't think it could happen to lawyers. I promise you, it's not necessarily going to happen to lawyers, but there is an opportunity for bad things to happen to lawyers who don't pay attention to cutting-edge technology and who don't deal with the clients in the way that clients are used to or want to be dealt with. MyCase allowed me to do a little plug for my blog, lawpracticetipsblog.com. You can come subscribe to that by RSS, or if you'll see at the top, you can enter your email address, and then you'll receive the blog post the next day via email. I'm almost out of breath, Stephanie, but let's see if we got any questions.
Well, you have perfect timing, so thank you. Yes, there are questions, and I have a feeling there's a lot more pouring in right now, but just a few things before we get to those great questions. For those of you who have to leave us now, please take note of 3 things. When you close your webinar, a quick 5-question survey will pop up. All it takes is just 30 seconds and answer those questions. You're entered to win a $100 Apple gift card. Someone wins every month. If you are a Florida bar member, note CLE course number 2505R to self-report your CLE. And again, we don't provide certificates, but you can use this webinar to self-report. And everyone will receive an email tomorrow with a link to the blog where you'll find these slides, the webinar recording, and the Apple gift card winner. All right, so moving on to some of these questions, Jim. A lot of people did ask about the terms of service that you mentioned at the beginning. And someone asked, when you speak of terms of service for the cloud provider, are you referring to the what ifs, like catastrophic damage to the server, etc., and what happens? Are the terms of service usually specific as to most of those kinds of possibilities?
Often they are not that specific, and of course I'm not a total expert in this. When I get ready to do a terms of service review, I actually Google reviewing terms of service and look at a few articles myself to kind of get my thinking going in that way. The one term of service we'd be really interested in is what they talk about with downtime. Most of them will promise 99.9% uptime. Another important term of service is where your data will be stored. Who has access to your data is another question. Some lawyers are very concerned, and they want what they call zero knowledge, where nobody in the firm has any ability, even when they're trying to help you or work with you, nobody in the provider can access your password or access your account. They can only reset it and send it to you. That's called zero knowledge. The problem with some of these, if there's zero knowledge and zero password recovery, if you forget your password, you're dead, dead, dead. And so I'm not troubled by the fact that 3 or 4 specified security people at a company have that ability, because if you pass away and nobody knows your password, it can be great help for your family. If you're disabled, there's lots of scenarios where the company can help you out. So I'd want to be concerned about that and pay attention to that. The upside, the downside, where the data is stored, what happens if you don't pay, how long do they maintain your data before they delete it if you don't pay, because, you know, again, if you're in the hospital, that might happen inadvertently, or a credit card could get changed or whatever. So we lawyers are used to reading long, complex documents, but as a society now, what do? We click OK instead of reading those. And I'm just suggesting, if it's going to be client data, you want to be able to read it, review it, but also, if you're ever questioned about it, say, yes, I read the complete terms of service.
Great. Thank you for that answer. Next question. You talked about things like Citrix share file. Do Dropbox and Adobe Send have the same sort of protection?
Dropbox is clearly encrypted now, and any problems with Dropbox, and they left the door open, you know, many years ago, and they got a lot of flack over that. So I think the Adobe is meant to be secure, but Uh, I'm really to the point where I want you to pay for something, and so I think Dropbox is secure, but I would look at how much the paid account for Dropbox is and whether that provides me much more. I'm not going to speak to that right now because it kind of changes, uh, but certainly but when you get past Dropbox and you start looking at Evernote and all these millions of providers, how am I going to know they're secure? How am I going to know if another company changes? Uh, I think you want to have a couple of main providers. Here's where I keep my secure information, and here's all the other ones that I play with for fun or I don't keep secure information in. And then that way you can kind of stay in an update. But I use Dropbox extensively. I like Dropbox. It's my favorite tool, really. It just so happens that I don't have any need to store confidential information in Dropbox. But I would look at all of. I would just do some research, and you can Google things. I mean, you got to know who's answering, but you can Google things like is Dropbox secure or whatever, and you get a lot of crazy articles on both sides of the fence. But you may find some law practice management expert, like somebody who's been at ABA Tech Show or something, that you can count on what they say.
Okay, great. And moving on to our next question, Jim. Our firm uses the free version of G Suite that no longer is offered. Is this, which is like legacy no longer available software, free version of G Suites, as acceptable tech safety-wise as the $5 a month version of G Suite?
I'm not familiar with that particular answer, so I'll have to hedge a little bit. But I would say it depends on if you're legacy, which means you're free but it's still being supported, or if it's no longer supported. We just can't afford to use anything that's no longer receives security updates and whatever. But if you got something, you sign up now and you get it for a lifetime, and it's the same as the other G Suite you pay for, that's certainly more secure than the normal Gmail, and I would feel comfortable with that. Sorry, I don't know the specifics on how people get those legacy free copies to speak any further.
Okay, great. Lots of questions pouring in. Can you speak briefly about website accessibility? There have been news stories lately about firms being sued because their websites are not accessible.
That's where I'm not an expert in that area. I have heard of larger law firms with deep pockets being sued for that. I think that's a matter between you and your website designer, and I would want representations from them that they've made it ADA accessible. An important business corollary, it doesn't get you sued and whatever, but I'm also very concerned that your website is mobile friendly. Most new clients now, particularly for consumer clients, will look to you first on the website. They'll look to you first on the website on their phone before they ever go to a computer. So you need to deal with a website designer who can build a ADA compliant site and will represent to you in writing that they've done so.
Okay, great. That's interesting. I was not aware of that. Next question. What duties do you have to educate associates or paralegals in your office? I know you briefly touched on that. So.
Right. I think as a practical matter, you have a business need to do that, because if somebody clicks on a ransomware and it shuts down all your office computers, there's a whole business problem unrelated to any ethical duties to your client. But when I went to law school, that's why lawyers are so bad at delegating. They say you can delegate to whoever you want to, but you're still responsible if something goes wrong. And I think for employees, that is, your employees are under your care and under your direction, and you're going to generally be held liable for things they do in a damages sense, if not in an ethical disciplinary sense. If you have outside contractors, again, I'd get representations from them that they understand that. If you've got a lawyer who's of counsel now, I think you have a duty to kind of work with that lawyer and have them send you an email saying they understand some of the things we've talked about today about security. But yes, for good or bad, I think you are responsible for your employees and knowing how to behave in this new age.
That's a fair answer. Okay, next question, and probably our last, because we are down to the last 2 minutes. Any guidance on implementing retention and destruction policies for cloud-hosted files?
What a great question. We may go a minute long on that one. if you represent businesses and you don't have a file destruction policy, you could find yourself in a position where when the client is being sued, they have, pursuant to their regular file destruction policy, destroyed all the information, and yet it's still sitting in your office because you didn't destroy it. So with corporate clients, you want to be aware of their destruction policy. Most bar associations don't have a bright line file destruction policy. We say kind of 5 years around here because the rules say trust accounting records have to be kept 5 years, and much of the file supports the trust account records, but that's not a controlling situation. But I do believe you have the obligation to destroy at least part of the digital file. I don't think you have any obligation to destroy who the client was, what you did, what the case number was. You have a certain right to keep some of that information forever to protect yourself on down the road. But I would certainly think that destroying digital information is important. And this brings up probably my final point, which is we keep that digital information to reuse it again. So a part of the file process should be the lawyer doing an analysis on, did I do anything in this file? Did I create any document, any plan, any estate plan that's new and novel that needs to be saved to be reused later? So you move that from the client file to the form file, and then you assign a paralegal to sanitize it of all the client name, dates, and all that stuff, so you just have a form left. So if you keep those forms for your reuse, then it's a lot less painful to have to destroy those client files. But I'd always keep my contact information on every client file. If I get called 20 years from now and say, did you represent this client 20 years ago, I'd like to have some process where I can answer that question. Thanks very much for your attention, folks. I hope you've enjoyed the program.
Thank you so much, Jim, and thanks to everyone who attended. We'll see you next month.